This year's GI Film Festival San Diego takes place May 6th through 8th and is sponsored by Creative Forces Community Engagement Grants, part of the National Endowment for the Arts Creative Forces Initiative in partnership with Mid-America Arts Alliance. Festival details at gifilmfestivalsd.org.
Welcome in San Diego, it's Jade Hindman. On today's show, we're talking about the Supreme Court's recent ruling on a Louisiana district map and its impact on elections with UC Berkeley law professor and author Kiara Bridges. This is KPBS Midday Edition, connecting our communities through conversation. It is striking how often in America and in American history, access to political power expands and then quickly contracts, and how lessons from the past seem to go ignored, which leads us to now. Just 44 years after Section 2 of the Voting Rights Act was amended to prevent racial discrimination in voting, the Supreme Court, in a recent decision, a 6-3 decision, voted to weaken federal enforcement of it. It's a case called Louisiana v. Calais. And the question is, what did history already tell us about easing the federal enforcement of voting rights? And what does that mean today? Well, Kiara Bridges is a professor of law at UC Berkeley who works and examines race, law, and inequality. She's also authored numerous books, including her latest title, Expecting Inequality: How the Maternal Health Crisis Affects Even the Wealthiest Black Americans. Professor Bridges, welcome back to Midday Edition.
Thank you so much for having me. It's a pleasure to be here, although under terrible circumstances.
Yes, indeed. And I want to go back and correct the title of your book. It's Expecting Inequality, not Inequality. So, but yeah, here we are. It could be under better circumstances, but help sort this out for me, because central to Louisiana v. Calais was a redistricting map. What issues around that were being argued?
Well, Louisiana had, in light of the 2020 census, created a map that contained only one majority Black district. And there were challenges to that map because the challengers said that, well, this would be a violation of Section 2 of the Voting Rights Act if Louisiana, which is a state that has a Black population of about a third, only had one congressional district in which Black voters were a majority. So Louisiana issued another map that contained two Black majority districts. And that map was challenged as a racial gerrymander. Essentially, a group of white voters or organizations representing white voters said that second map, the second drawing of the 6 congressional districts in Louisiana was a violation of their constitutional rights because Louisiana was mindful of race in creating the second congressional map. And so after some back and forth between the Fifth Circuit and the District Court, it ended up in the Supreme Court. And the Supreme Court just last week used that battle over that second congressional map to gut the Voting Rights Act and to essentially neuter the remaining power that the Voting Rights Act of 1965 retained.
And just to be clear on this, so that I understand and so everyone understands, that second voting district, did that give fair representation to Black voters?
Well, yes, the second voting district, in which it would be a Black majority of voters, sort of helped. Again, Louisiana, the population of the state is 33% Black. And so a congressional map in which there were 1 out of 6 districts in which Black people were a majority, the Black voters would be underrepresented, right? Their political power would not be equivalent to their numerical power in the state. And so that second map that was challenged and which was struck down in Louisiana versus Calais, that map would have done a better job of ensuring that Black people in Louisiana were able to be represented in the halls of power in D.C.
And the dissenting opinion on this, it was a sharp rebuke. What stood out to you in that?
Well, what it stood out to me is that I adore Justice Kagan. I think that she pulled no punches. She told it like it is. And so, what Kagan makes clear in the dissent is that the majority it doesn't say that it is reversing any precedent. It doesn't say that it is ruling unconstitutional the Voting Rights Act. Instead, the majority couches or describes this opinion as sort of just like a refurbishing of the Voting Rights Act. So we're just going to bring it up to date. But that refurbishing, as I've already said a couple of times, there are no components of the Voting Rights Act that have any power right now to challenge and to limit and to restrict all of these efforts by many, many, many states in the South primarily that are working really, really hard to silence Black political voices. And so what Kagan says, she says what goes unsaid in the majority opinion, which is that this opinion is extreme. The majority's opinion is radical. It guts the Voting Rights Act. The Voting Rights Act is effectively nullified, and it's a gross departure from the precedents that came before.
And the majority opinion pretty much points to, they feel there should be race neutral policies for drawing these maps, and also that using partisan maps, that's perfectly legit. Talk to me a bit about that. Is it possible to be race neutral and partisan in America?
Right. I mean, so the court actually doesn't say, and I've read the majority opinion a couple of times now, and the majority opinion doesn't actually say that it doesn't require race neutrality when it comes to drawing these congressional districts. Instead, the court says we cannot have congressional districts in which race appears to be the only factor in constructing the various districts. Essentially, the court is requiring legislatures, and they will be happy to do so, to couch any racial intent behind partisan interests. And so if Louisiana can say that it eliminated this, Black majority district because it was interested in protecting Republican candidates, Republican incumbents, and making sure that, Republican candidates would be able to secure the majority of the votes in a district, then that's okay. If they also had race in mind, okay, that's fine. But as long as there was some desire around protecting Republican candidates or in the inverse, protecting Democratic candidates, then that's okay. But the court says what's problematic is when you are conscious of race, particularly to protect Black voting power. And so that's precisely what Louisiana did when it constructed this second congressional, districting map. It was conscious of race because it didn't want to run afoul of the Section 2 of the Voting Rights Act. And the court says that that is illegitimate. And so just to put a finer point on it, if you're conscious of race in order to protect Black voting power or the voting power of racial minorities in a state or in a district, well, that's problematic. That is illegal. But if you're conscious of race and can manage to gussy it up as being interested in partisanship, well, that's perfectly permissible under the law.
So right now, we see a number of states rushing to redraw their maps. How do you think this decision will impact midterms and the 2028 elections, just, in our not so distant future?
Yeah, a lot of my academic colleagues who are, into the number crunching of it all, they've come up, with different numbers. Nicholas Stephanopoulos at Harvard says that, 70 seats, hang in the battle, in the balance. Other academics give different numbers. Some say 30, some say it's in the dozens. That being said, it's impactful. And I think only time will tell how it will, shape the midterm elections and, which candidates will no longer have their seats. Like you already mentioned, states are chomping at the bit Florida is active right now. They got activated, and they're actively working on redrawing their maps so as to diminish Black voting power as much as they possibly can in that state. So this is a very impactful decision. It's a very radical decision, and any description of it as anything less than that is inaccurate.
What's the local impact of a decision like this? Because it's not just what happens on Capitol Hill, correct?
Oh, absolutely not. So we're talking about everything from, school boards to city councils, the municipality level, like all of these areas of where you cast a vote for anything will be impacted by Louisiana versus Calais. And, as someone who works on Black maternal health, a lot of these solutions are at the local level. Of course, the federal government could do something grand like pass the Omnibus Act. I'm not holding my breath for that. But at the local level, localities can fund doula care, they can fund midwives, they can support community-based organizations, right? There are a lot of things that government can do at the local level to address the problems that are salient to the community, like Black maternal health, like policing, like the quality of the schools. But what Louisiana versus Calais does is diminish the power of these communities to actually get a majority to elect folks into the halls of power. And so the issues that affect them will go unrecognized in the political sphere, or rather they will go unacted upon in the political sphere. And so it's just bad, not just for DC, but it's bad just for local government as well.
You've written extensively and studied and researched about how systems can reproduce inequality while language around the system can appear race neutral. In what ways do you see that being reflected in our voting process right now?
Well, I think that Louisiana versus Calais is an example of structural racism. It's an example of like the steadied refusal to name race and the persistence of racism in the present. And what that is going to do is allow for legislatures to silence people of color, silence minorities. And so all of the voting map, Florida right now, the map that it may generate and, may get put into administration, that map will say nothing about race. It will have nothing. It will on its face. It will say nothing about this map. The intent of this map is to diminish Black voting. This is to dilute Black votes, right? It will never say that, but that will be its effect. And that effect will, as I mentioned just now, it will impact the ability of people to cast votes after they have been released from jail and prison, right? It will impact the funding of Medicaid in the state. It will impact what books get taught or cannot get taught anymore in K through 12 schools and in higher education in the state. So again, these will be race neutral maps, but they will have the effect of reiterating racial inequality in the state and in the nation more generally.
What does history tell us about this moment in time? Because it rhymes, correct? So, what can we take from history on this?
I mean, so one of the most ironic parts about Louisiana versus Calais is that this is the same supermajority that purports to be so very interested in history when it's handing down these originalist interpretations of the 14th Amendment due process clause, for example, or the Second Amendment right to bear arms, right? So when you look at those cases, this majority dives deep, deep, deep into the history books in order to come up with a regressionist interpretation of the Constitution, a very conservative interpretation of the Constitution that just happens to align with the Republican Party's platform. But it's really odd that in Louisiana versus Calais, that history doesn't really make an appearance at all in the majority opinion. The court doesn't mention why the 15th Amendment was passed in the first instance as, one of the Reconstruction Amendments after the Civil War. It doesn't mention the bloodshed of the Civil Rights Movement that led to the passage of the Voting Rights Act of 1965. Justice Kagan has to do that work in her dissent, where she reminds the public, anyone who's reading this opinion, as well as the majority, that the point of the 15th Amendment, as well as the Voting Rights Act, was to ensure that Black people could cast a meaningful vote and to ensure that there would be Black representatives and senators in the halls of power. And so it is a focused determination to ignore history that allows the majority to come to the decision that it reaches in Louisiana versus Clay. And I'll also mention it's a opinion that denies that racism persists in meaningful ways in the present. It's part of this, and it's very odd to say it in a country in which we have a Trump administration, which intentionally and obviously trades on racist discourses. We have a Supreme Court that is leaning on this old colorblind canard that the bad old days of racism have passed and that we are in this colorblind future where we can ignore race without deleterious consequences.
Well, and perhaps we'll have to look at history to find a solution to this as well. I've been speaking with Khiara Bridges, professor of law at UC Berkeley. Her work examines race, law, and inequality. Her latest book is called Expecting Inequality, How the Maternal Health Crisis Affects Even the Wealthiest Black Americans. Professor Bridges, thank you so much for your insight.
And thank you for having me.
That's our show for today. I'm your host, Jade Hindman. Thanks for tuning in to Midday Edition. Be sure to have a great day on purpose, everyone.
Before a producer hits record or before a journalist picks up a pen, someone like you notices something and wants to understand it. Every day, we invite you to keep asking questions like why and who and how. Because NPR begins with questions, not conclusions. And your right to curiosity is a right worth protecting.